Good morning, everyone. We are delighted that you've all been able to join us this morning for this important strategic webinar. I'm Catherine Glenn Foster, President and CEO of Americans United for Life, and I'm joined today by our Senior Counsel, Clark Forsythe, and Gene Schaerr, who is partner with Schaerr Duncan. Last night, as you know, President Trump nominated Judge Brett Kavanaugh to be the next Supreme Court Justice, and we congratulate Judge Kavanaugh for this achievement. Judge Brett Kavanaugh is an influential federal judge. He is committed to the text and to the original public meaning of the Constitution, and we expect that he will be confirmed by the Senate. Judge Kavanaugh was born in Washington, D.C. in 1965, attended Catholic elementary and secondary schools. He earned both his BA and his JD at Yale and served as notes editor of the Yale Law Journal. After he graduated from law school, Judge Kavanaugh clerked for a year for the U.S. Court of Appeals for the Third Circuit and then on the Ninth Circuit Court of Appeals for Judge Kaczynski. And then he briefly worked at the Office of the U.S. Solicitor General, and in the fall of 1993, he became law clerk to U.S. Supreme Court Justice Anthony Kennedy. In 1994, Judge Kavanaugh became an associate counsel for Kenneth Starr's Office of Independent Counsel in Washington, D.C., retaining that position until 1997 and then again briefly in 1998. He entered private practice in Washington, D.C. before going on to serve as counsel in the George W. Bush White House. Then he became assistant to the president and staff secretary. President Bush first nominated Judge Kavanaugh to the D.C. Court of Appeals in 2003. He received a hearing from the Senate Judiciary Committee on April 24, 2004, did not receive a vote, and his nomination expired. The President renominated Judge Kavanaugh on February 14, 2005, and after a second hearing and a Senate vote of 57 to 36, he was appointed to the position on May 30, 2006. He and his wife have 2 children. Judge Kavanaugh is really highly regarded on all sides for his judicial experience and for his commitment to thorough preparation and thoughtful analysis. During the 12 years that Judge Kavanaugh has served on the U.S. Court of Appeals for the D.C. Circuit, he has authored nearly 300 opinions, including leading judicial opinions on the Second Amendment, on campaign finance, religious liberty, administrative agencies, and the separation of powers. The Supreme Court has often relied on Judge Kavanaugh's opinions numerous times in reaching its own decisions. So this is our chance to shift the court back to a majority that does not look to Roe and Casey, recognized by the left as well as the right as 2 of our nation's worst examples of judicial activism as their legacy, someone who looks to the Constitution as his highest calling and duty and to the rule of law, including respect for human life. And we've seen that that is something that the American public supports. While we've seen certain polls recently with limited questions asking simply, do you support overturning Roe? And that's about the extent of the question. When we've seen that kind of question, many in the American public say, well, no, we don't want Roe overturned. But as soon as you get to the heart of the matter, and for example, in the latest Gallup poll that came out a couple of weeks ago, we see that in fact, the American public does want to see a shift towards life. And what we've seen is that since the mid-1990s, the percentage of Americans who describe themselves as being pro-life has skyrocketed by 15%. We've seen that there's a real gap, a 5% gap in the percentage of Americans who say that abortion is morally wrong versus those who think maybe it might be morally okay. And when you ask when different Americans believe that abortion should be legal, a majority of Americans believe that abortion should be legal in either no or very limited circumstances, which requires turning back Roe and starting to make those incremental changes, eventually overturning Roe. Yet already last night, abortion activists have been seen massing and agitating for so-called abortion rights right in front of the Supreme Court. It was all over the news. And they're going to fight Judge Kavanaugh's nomination. So we have gathered here today so that we can go behind the scenes to discuss this Supreme Court nominee, Judge Kavanaugh, his judicial philosophy, what comes next, and this once-in-a-lifetime opportunity to restore respect for the right to life on the U.S. Supreme Court. We have again with us Gene Schaerr. He is partner at Schaerr Duncan, LLP. He specializes in handling civil appeals, writ proceedings, and similar matters in appellate courts and in law-focused proceedings at the trial court or agency level. He has argued and won dozens of cases in a variety of forums, including the U.S. Supreme Court, where he has argued 6 cases. He has argued in every federal circuit and in numerous federal district courts and state appellate courts. His win rate in the dozens of federal appeals he has argued in the past 6 years is over 75%. He has a long and distinguished career, as has been named as one of the best lawyers in America, Legal 500, DC Super Lawyers, is now with Schaerr Duncan and doing just a marvelous job there. His experience includes not only virtually every area of federal law, defamation, higher education law, immigration, insurance coverage, labor and employment, patent and trademark, privacy, product liability and warranty, statutory interpretation and tax, virtually every sector. But in addition, he has clerked for the U.S. Supreme Court for Chief Justice Warren Burger and for Justice Antonin Scalia, and on the U.S. Court of Appeals for the D.C. Circuit for then-Judge Kenneth Starr. He's a graduate of Yale Law School, was editor-in-chief of the Yale Journal on Regulation, and senior editor of the Yale Law Journal, was associate counsel to the president at the White House from 91 to 93, and we are just delighted to have him with us today. We will also be hearing from Clark Forsythe, Senior Counsel at Americans United for Life, and the author of Abuse of Discretion, The Inside Story of Roe v. Wade. That has been favorably reviewed in the Wall Street Journal, the Chicago Tribune, National Review, and other journals. And Jeffrey Rosen, president of the National Constitution Center, wrote in the Wall Street Journal that abuse of discretion provides a cautionary tale about the political and constitutional hazards of unnecessarily broad Supreme Court decisions. Clark has been co-counsel for parties in 3 Supreme Court cases and has argued before federal and state appellate courts. He's also testified before Congress and state legislatures, has authored or co-authored 20 professional legal articles on constitutional and bioethical issues, and his latest, a draft opinion overruling Roe v. Wade, is going to be published in the Georgetown Journal of Law and Public Policy this August. His other articles have been published in the Wall Street Journal, LA Times, The Federalist, The Hill, and other newspapers and magazines. His first book, Politics for the Greatest Good, which draws on lessons in political prudence from Thomas Aquinas, William Wilberforce, and Abraham Lincoln, was published in 2009. He has a BA from Allegheny College, a JD from Valparaiso, and an MA in bioethics from Trinity International University, where he is an adjunct professor of bioethics. He and his wife, Karen, married for 36 years, have 5 daughters. I'd like to start off with Gene, who will provide some of the background of Judge Kavanaugh, of this process, Judge Kavanaugh's philosophy, and some behind-the-scenes perspective on the court itself. Gene?
Well, thank you, Catherine. It's a pleasure to be here today. I had the privilege of working on Clarence Thomas's confirmation while serving as an associate counsel to the first President Bush. And I think there are some parallels between that situation and the confirmation battle that I think we're likely to see with respect to Judge Kavanaugh. For example, in the case of Justice Thomas, the White House asked then Senator John Danforth, who knew Clarence Thomas very well, to head the effort in the Senate to get him confirmed, and of course that effort was ultimately successful. In the case of Judge Kavanaugh, we learned yesterday that the administration has asked a former senator, Senator John Kyle of Arizona, to shepherd Kavanaugh's nomination through the Senate this time. And in my view, the confirmation process will likely have 4 distinct stages or phases. Stage 1 has already begun and will swing into action in greater force right now, and I would call that phase preparation for the hearings. Most of the action in the short term is going to be in the Senate Judiciary Committee, and the minority staff of that committee, which of course is overseen by the ranking member of that committee, Senator Dianne Feinstein, will be furiously looking for dirt of any kind on Judge Kavanaugh. Of course, during the Thomas confirmation, the Democratic staff of the Judiciary Committee found Anita Hill, who went on to accuse now Justice Thomas of inappropriate language and behavior during his private government service when she worked for him. Well, knowing Judge Kavanaugh as I do, I doubt the Democrats will find any credible dirt of any kind on him, so they'll likely focus on his judicial views and will argue that application of those views will be bad for women, minorities, members of the LGBT community, etc. That tactic, as many of our listeners may remember, was enough to defeat Robert Bork in 1987 in an effort that was led by the then chair of the Judiciary Committee, Senator Joe Biden, who of course went on to become vice president under President Obama. I doubt that will happen this time around. I don't. Judge Kavanaugh is a very skilled and I think persuasive advocate for what some people call the textualist or originalist view of how to interpret the Constitution, and I doubt that he'll make the kinds of mistakes that Judge Bork made that led to his defeat in 1987. But I'm sure that's what the Democrats on the committee will be hoping to produce, is another Senate rejection of an originalist potential justice on the Supreme Court. On the other hand, there's also a good staff of lawyers on the Judiciary Committee who work for the majority on that committee, and that staff is overseen ultimately by the chair of the Judiciary Committee, Senator Grassley, and those folks will be working feverishly to counter any arguments that the Democratic staff or others advance against Judge Kavanaugh. So that's stage one. Stage two will be the Judiciary Committee hearings themselves. Now, Majority Leader McConnell has said that the hearing will likely be in September or October. And, of course, friends and foes of Judge Kavanaugh will testify during that hearing. It may extend over several days. And in the end, both sides will be trying to accomplish two things. Now, remember that the current Republican-Democratic split in the Senate is 51-49 in favor of the Republicans, and that Vice President Pence can vote to break a tie. So the Republicans have a margin of error, but it's a very small margin, and so both sides will be trying very hard to persuade the two moderate female Republican senators, Senators Collins and Murkowski, to vote either for or against Judge Kavanaugh, and both of those senators have expressed support for abortion rights. Both sides will also be trying to persuade a couple of Democratic senators in states that Trump won, Senator Joe Manchin in West Virginia, Senator Heidi Heitkamp in North Dakota, both of whom are up for re-election this year. And for those senators and in those states, the most potent argument in favor of Judge Kavanaugh is probably that his presence on the court is necessary to preserve the 5-4 Supreme Court Second Amendment decision known as the Heller case that dealt with gun rights. Although it's possible that abortion may figure in some of those races as well. So that's stage two. Stage three, what I call the political campaign. I've already alluded to that a bit, but again, the political campaign will be focused on moderate senators of both parties who haven't, at that point, publicly committed to one side or the other. And as we've seen, groups on the left have already been preparing the groundwork for that political campaign by running ads calling on senators to press Judge Kavanaugh on issues like abortion and reproductive rights. We also know from news stories that groups on the right have been raising funds and gearing up to support Judge Kavanaugh politically through ads in selected states and trying to sway the views of particular senators. So that's stage three. Stage four will, of course, be the vote on the confirmation, and that could end up being fairly dramatic. I hope it won't be dramatic. I hope because I really believe Judge Kavanaugh, whom I know fairly well, I believe he deserves to be confirmed by a very wide margin, but the vote will be held in in probably late September or sometime in October after the hearings conclude. So that's just a brief outline of the process. And let me just spend a couple of minutes on Judge Kavanaugh's judicial philosophy, which Catherine has alluded to. And as I mentioned, his judicial philosophy is, at least as he's expressed it, is similar to the approach that Justice Scalia applied quite consistently as a justice. It's also similar to the approach that Justice Kennedy has often articulated as the appropriate way to decide cases. Although I think most people would argue that Justice Scalia was more consistent in adhering to that approach than Justice Kennedy has been. But let me just briefly quote a lecture that Judge Kavanaugh gave in 2016 in honor of Justice Scalia after Justice Scalia's passing. And it was this lecture was given in the form of advice to other judges or to new judges. And Judge Kavanaugh said this. He said, "The judge's job is to interpret the law, not to make law or make policy. So read the words of the statute as written, read the text of the Constitution as written, mindful of history and tradition. Don't make up new constitutional rights that are not in the text of the Constitution, and don't shy away from enforcing constitutional rights that are in the text of the Constitution. Changing the Constitution," he said, "is for the amendment process. Changing policy within constitutional bounds is for the legislatures." And I'm convinced that that's the approach and the philosophy that Judge Kavanaugh will bring to the court if he's confirmed, as I certainly hope he will be. Now, one important issue of judicial philosophy that I suspect will be significant during the hearings and during some of the politicking that will surround the confirmation is Judge Kavanaugh's views of what is called stare decisis, and that is the issue of when, if ever, is it appropriate for the Supreme Court to overrule one of its past precedents, such as Roe versus Wade. That is something that Judge Kavanaugh has written about, and it's clear from his writings that he is not somebody who believes that the Supreme Court precedent should just be overruled willy-nilly, but nor is he someone who believes that it's never inappropriate to overrule a prior precedent of the court. And he's a co-author of a book written with some other judges, including Justice Gorsuch, called "The Law of Judicial Precedent," and that book has a pretty good discussion of the various factors that Supreme Court justices should take into account in determining whether to overrule a past precedent. And those factors turn on things like the extent to which the decision at issue has been acquiesced in by the public, the extent to which it's been relied upon by the public, and of course just generally the importance of the issue. And this book makes clear that it is more appropriate to consider overruling a past precedent when that precedent is an interpretation of the Constitution. And the reason for that is that, of course, the Constitution is very difficult to amend. If the Supreme Court misinterprets a statute, Congress can, of course, just rewrite the statute or amend the statute to fix the problem. But in the case of a constitutional interpretation, there's no political body other than the people as a whole through the very cumbersome amendment process that can change an outcome of a Supreme Court decision interpreting the Constitution. And so Judge Kavanaugh, like most judges, has expressed the view that it should be at least somewhat easier to overrule or overturn a past precedent of the Supreme Court on a constitutional issue than on a statutory issue. But I think it's also fair to say that based on his public writings, it's it's going to be impossible to know at this point. It'll be impossible to predict whether he will ultimately be willing to vote to overrule any particular prior precedent of the U.S. Supreme Court. And indeed, my guess is that as a good, fair-minded judge, he has probably not even made up his own mind at this point which of the Supreme Court's opinions he would and would not vote to overrule. That decision will depend in large measure on the arguments that are presented at the time. So that'll be an important issue to watch, and a lot of people will try to get Judge Kavanaugh to commit in advance that he either will or will not vote to overrule Roe versus Wade, for example, and perhaps some other decisions that are hot button political issues. So I think that's a bird's eye view of his judicial philosophy and the process that will lead up to a decision on whether the Senate confirms him or not. I think inside the court, inside the U.S. Supreme Court right now, there are a lot of people who are cheering for Judge Kavanaugh. As many of you may know, Judge Kavanaugh actually clerked for Justice Kennedy and with Justice Gorsuch. So the three of them are obviously good friends, and I'm sure both of them are rooting for him to get confirmed. If he is confirmed, his confirmation will be quite an accomplishment for Justice Kennedy, because I believe Justice Kennedy will become the very first U.S. Supreme Court justice in history to have two of his law clerks confirmed as justices on the Supreme Court as well. So I'm sure that's if Judge Kavanaugh is confirmed, I'm sure that's something that will be a source of great pride, and justifiably so for Justice Kennedy. So with that, I'll turn it back to you, Catherine, or to Clark.
Wonderful. Thanks so much, Gene. Clark?
Thank you, Catherine. I'm glad Gene went first and gave an overview of Judge Kavanaugh's record and his judicial philosophy, because I think that his general philosophy may be more important than any particular cases he has decided for predicting his performance on the Supreme Court. I think Judge Kavanaugh should be judged based on his public record, and it is an extensive and impressive public record. He's served 12 years on the D.C. Circuit, written nearly 300 opinions, and those have been, in many instances, on very consequential and weighty federal and constitutional questions. And they tell us a lot about his overall philosophy. Now, for me personally, in anticipating change in the Supreme Court and the Kennedy retirement specifically, my thoughts have primarily been drawn to three specific issues: Roe versus Wade, the question of precedent and how a new justice might address precedent, as Gene summarized, and maybe more broadly, how a new justice would view the legal protection of human life generally. And although that hasn't been given much attention, I think it may be very important over the next 2 or 3 decades that Judge Kavanaugh might be on the Supreme Court. It's a question of judicial philosophy and the role of judges, but I think it's also a question of leaving issues to the democratic process and leaving issues to the states. And I think Judge Kavanaugh's judicial philosophy will lead to general protection of human life, in the sense of his view of judicial restraint, his view of leaving issues to the democratic process, and his, I think, respect for federalism. And it is, I think, over the long term, it is the states where that have the greatest authority to protect human life, and where really much governmental action to protect life takes place. On the question of Roe, I don't think that you can tell, as Gene alluded to, you can tell much about Judge Kavanaugh's philosophy or his approach. He really hasn't, because he served on the D.C. Circuit and not on other circuits that address state legislation involving abortion, he hasn't had that type of a case. But if he had, I'm sure as a lower court judge, he would have respected precedent, because he has said that he recognizes he is a lower court judge. In fact, in the HHS mandate case, the Priests for Life case, in which he dissented, he said, "We are a lower court in a hierarchical judicial system headed by one Supreme Court. It is not our job to relitigate or trim or expand Supreme Court decisions. Our job is to follow them as closely and carefully and dispassionately as we can." So to some extent, the irony is that he hasn't been faced with overruling Supreme Court decisions because it's not his job. He can't do it. The Supreme Court has repeatedly said that the lower courts can't revise or cut back on or reinterpret Supreme Court decisions. They have to scrupulously follow them to the extent that they control any particular case. So it's not surprising that he hasn't addressed questions of overruling Supreme Court decisions. But Gene gave a general overview of precedent and the factors of precedent, and Judge Kavanaugh, because of his role in a lower federal court, has not expressly addressed the factors of stare decisis, much at all in the decision of particular cases. I won't go into the 6 factors of stare decisis in detail, but I think they can be reduced to 3 questions. Was there error? How bad was the error? And what's the cost of correcting the error? And those are questions that, in fact, Judge Kavanaugh will really address for the first time as a Supreme Court justice in reviewing precedent, because those aren't questions he can address as a lower court judge. And so I to my mind, the burden is still on pro-life organizations and pro-life attorneys in the years ahead to show that Roe was wrongly decided, that it is unsettled, that it was wrongly decided, that the error has been great, and that the error is so great that the court should return the question to the American people and the democratic process at the state level. But the burden is still going to be upon us, I think, to demonstrate that to a majority of the court going forward. And I don't want to underestimate the obstacles to doing that. As we all know, the abortion advocates have made a central focus of Roe versus Wade. Even before a nominee was named, they were claiming that the next nominee would overturn Roe versus Wade, which is obviously foolish because no one justice can overturn a Supreme Court decision. We should not exaggerate or have exaggerated expectations at this time that Roe versus Wade will be easily overturned. We need to continue to think through every possible hurdle and how to overcome them. And because the obstacles to overturning Roe are still enormous, and because there are still enormous forces in American society trying to prop up Roe, we really need to focus on what I call the 7th but the silent factor of stare decisis, and that is the political climate, meaning we still need to elect a president and a Senate who will continue to be opposed to Roe versus Wade, and we really need to create a positive political climate where pro-life candidates are winning in Congress, winning at the state level, and to continue to show that the American people support returning the issue to the people in the democratic process in the states. And those are issues that can't be addressed in any nomination or in any judicial confirmation hearings, because they are the people's work through the political and the democratic process, and I think we have to remember those moving forward. Back to you, Catherine.
Great. Thanks so much, Clark. Really appreciate your thoughts on that, and thank you as well, Gene. Loved your behind-the-scenes perspective and just background knowledge on Judge Kavanaugh. You're right. We do need to create this positive political climate and demonstrate to our elected representatives that, in fact, the American people do support rolling back Roe v. Wade and eventually overturning it. But this is a critical opportunity as well to shift the balance of the court to a majority of originalist justices who do look to the Constitution, to America's founding documents, and to the rule of law, including legal protections for life, as their highest calling and duty. And also a majority of justices who are not emotionally tied to Roe and Casey and who do not look to Roe and Casey as their legacy. So we at Americans United for Life are going to be working over the next months on this nomination and this confirmation process. We've been researching the potential nominees since the President first released his short list, and again are just delighted that Judge Kavanaugh has been named as the nominee. He certainly is someone who well deserves this honor. Now we have set up a war room here in our offices to see this confirmation process through, but we need the help of everyone who has joined us on the phone. First, we would ask that you would sign the petition to call for the confirmation of a justice who knows that his or her highest calling and duty is to the U.S. Constitution and our nation's founding documents, to confirm Judge Kavanaugh. And you can find that petition, and we'll be sending out links to all of this. You can find the petition at aul.org/petition. We'll be issuing daily updates on Judge Kavanaugh, on his judicial philosophy, his background, some of his rulings, legal perspectives on a lot of his opinions and writings. We'll be publishing those daily on aul.org/courts/nominations as part of our Kavanaugh report. And third, we would ask that you all contact your senators by phone, email, letter, and social media to express your support for the confirmation of Judge Kavanaugh. And you can get that information at aul.org/courts/confirmation. So 3 very important steps to take: signing the petition, getting those updates and educating yourselves, and third, contacting your senators. At this point, I'd like to turn to Q&A. And feel free to write in with that. But in the meantime, I'd love to just kick things off with just a little bit more discussion of what Judge Kavanaugh's confirmation could mean for Roe or for legislation relating to abortion, and those cases that are making their way through the court system now, including cases on mandatory taxpayer funding of abortion, different litigation on health and safety regulations, those common sense requirements that help protect the women who are going into these abortion facilities. Just some of these cases that are making their way through the court system even today.
Well, I think it would be valuable to start by saying, as Catherine and Gene, as you both know, the justices ultimately have the authority, the power, the opportunity to decide when or if ever they address particular cases or particular legal issues. And we have to look for kind of cues and and indications from the justices as to what issues they're interested in. They can decide to not hear cases for quite some time, not hear issues for years. But they will have the opportunity, even starting this fall, with a number of different abortion cases from around the country. One that is already pending at the court is whether the states have the legal authority under the federal Medicaid statute to exclude abortion providers. There are a number of cases at the court now. The court could decide in September whether or not to hear any of these cases. And I think, with respect to expectations, that over the next 1 or 2 or 3 years, it is more reasonable, more likely to think that the court will deal with health and safety regulations, limits on abortion, the question of public funding, and most likely that the court will put off and will likely not address in the coming few years the question of Roe versus Wade itself. So there are a number of cases that the court can deal with regarding marginal regulations and limits, and it will be interesting to see what the court does with every one of those.
Absolutely. And, also there's a lot of misinformation out there relating to many of the hot-button issues we've seen in the news, and I think that's probably part of what is stirring up all of that protest and so on that we saw, for example, at the court last night. Clark, maybe you could just give us an overview of what would actually happen if Roe is overturned, whenever that may be.
Well, that will also probably be part of the political campaign process, as Gina mentioned, with respect to this nomination and any future nomination to the court in the next couple of years. Much that has been discussed in the public debate is false and exaggerated. First of all, if the court overturned Roe versus Wade today, abortion would be legal in probably 40 to 45 states tomorrow, perhaps all 50, for the simple reason that most states have repealed their pre-Roe prohibitions. They aren't on the books. The regulations that are on the books might be enforceable, but few states have enforceable prohibitions before 20 weeks of pregnancy or even fetal viability. So there will be minimal immediate legal change. And I think it's also important to point out that the claim that women might be prosecuted or jailed for abortion is contrary to state priorities and state policies for a century before Roe versus Wade. The states treated women as a second victim of abortion going back to the beginning of the 20th century, and they focused upon laws that limited what providers could do. But they treated women as a second victim of abortion, and women weren't prosecuted. So that, too, unfortunately, has confused the public debate. But given what the states did for a century before Roe, I think it's certain that the states are not going to be prosecuting women for abortion. And so the issue will go back to the states, and the states will decide in the first instance what, if any, laws might be enforceable. Congress, as you know, could introduce, I think that bills might be introduced in Congress on both sides of the question, either to legalize abortion nationally or to limit abortion nationally. But I doubt that both houses of Congress would come up or agree on either. And I think that members of Congress will be inclined to leave it to the states at least in the short term, if not for many years to come.
Right, right. So overturning Roe is a critical step and would be a huge victory, but it would also not be the immediate ban on abortion that so many abortion proponents are sort of fear-mongering about. It would exponentially increase our work and our efforts state by state nationwide, and it would provide a lot more latitude for the states to try to regulate abortion and provide protections for women. Another question just came in. I think this probably is going to have to be our last one because of time. But we know that that the general philosophy of a nominee and of Judge Kavanaugh is more important than any individual cases that he's decided. But maybe Gene and Clark, you'd each like to take a couple of minutes to discuss Judge Kavanaugh's opinions in a couple of the cases that are coming up for discussion quite a bit over the last few hours as people really start to discuss and get in depth with some of Judge Kavanaugh's opinions and writings more broadly than just in our legal community. And in particular, I'm thinking of Garza, of the Garza case with the undocumented immigrant who was seeking an abortion, and in that Priests for Life, Little Sisters of the Poor case.
Sure. Well, I'd be happy to address the Garza case to start off. I think that's the one that deals with abortion, and it's interesting that hardly any of Judge Kavanaugh's decisions have dealt with abortion at all. That's just not a question that very often comes before his current court, which is the U.S. Court of Appeals for the D.C. Circuit. But the Garza case, as you mentioned, involved an undocumented alien who came into the country illegally and wanted to get an abortion, and represented by the ACLU, she succeeded in getting a lower court to order the U.S. government to provide an abortion for her and to facilitate her getting an abortion. That case came to the D.C. Circuit on an emergency basis. Judge Kavanaugh was the leader of the D.C. Circuit panel that heard that case on a very expedited schedule. He concluded, and the panel that had been appointed to decide the case with him concluded that this undocumented immigrant had no constitutional right to an abortion and no statutory right to an abortion provided by or facilitated by the federal government. So they voted to overturn the district court's injunction. After that, though, the plaintiffs in the case, again represented by the ACLU, persuaded the entire D.C. Circuit on which Judge Kavanaugh sits, all the judges. I think there were 12 judges on that court at the time. So all 12 judges, or whatever the number is, reheard the case and decided to reverse the opinion that had been written by Judge Kavanaugh, and actually granted this undocumented immigrant a government-facilitated abortion. Judge Kavanaugh filed a dissent from that decision, but ultimately the ACLU won that case on behalf of their client, and the abortion was performed. And I think that in terms of Judge Kavanaugh's judicial philosophy, I think at a minimum it shows that he is not willing to stretch the law in order to accommodate somebody who wants an abortion. Whether he'll be willing to vote to overrule Roe versus Wade down the road is a completely separate question. But it was clear from that decision that he, unlike some of the other judges on his court, he was not willing to stretch the law in order to force the government to provide an abortion for this young woman.
Right. And he actually cited the government's interest again in favoring fetal life and in refraining from facilitating abortion, and criticized the majority for inventing a new right to obtain immediate abortion on demand. And with that said, he also is known for his views on the limits on judges and on lower court judges as well.
Exactly.
Mm.
Catherine,
would you want to? Mm-hmm.
Yeah, Priests for Life. The Priests for Life case involved the HHS mandate, and Judge Kavanaugh wrote a dissent in that case. It was not a majority opinion, and he concluded that the majority of the panel, three-judge panel in that case, had misapplied the Religious Freedom Restoration Act, and he would have ruled for the plaintiff religious organizations. And he went through kind of a three-step analysis, but he started with that passage I mentioned previously. He said it's not our job to relitigate or trim or expand Supreme Court decisions. Our job is to follow them as closely and carefully and dispassionately as we can, meaning as a lower court judge. And he went through kind of a three-step analysis. He asked, did the HHS mandate substantially burden the religious organizations? Did the government have a compelling interest? And did it apply the least restrictive means? And he ultimately said that the government did not apply the least restrictive means, and that they should have, and he would have therefore ruled in favor of the plaintiff religious organizations. But he starts out by basically saying that this case is controlled by the Hobby Lobby decision of the Supreme Court. What has rankled some people is that he said that Hobby Lobby indicated that 5 justices, that a majority of the Supreme Court, would find that, in fact, the government had a compelling interest in compelling employers to provide contraception to their employees. So he was exercising judicial restraint in saying that a majority of the court in Hobby Lobby would find that there was a compelling interest. And yet he said, but even if the Hobby Lobby would say that there was a compelling interest, the government didn't use the least restrictive means, therefore I would have ruled in favor of the religious organizations.
Wonderful. Thank you, Clark. One quick last question that came in that I'll just answer quickly, came in through another channel, on the role and effectiveness of petitions and letters and outreach to senators. And that kind of means is really critical, and especially for senators who may be more on the fence. Some of these Democrat senators in red states that perhaps President Trump won in 2016. Some of the Republican senators who may lean being more pro-choice, but faced with the nomination and the confirmation process of a strong originalist textualist jurist, could be leaned upon to vote to confirm him. So it can make a real difference there. It can even make a difference with those who are more firmly opposed to an originalist jurist, because they'll start to see that, in fact, this is something that the American people care about, and that it's the majority of Americans who want such a jurist to be confirmed. But I would say that there can be a strong and a definite impact, and that such outreach from individuals and from groups to senators and to the Judiciary Committee is really critical in this process. Now, with that, we unfortunately are out of time. Thank you, everyone, for your questions that came in through various channels. Thank you very, very much, Gene and Clark, for joining us today. If you have any further questions or would like more information, please feel free to visit us at our website, aul.org, and hope you have a wonderful day. Again, please check out aul.org/court/nomination for the daily update with information on Judge Kavanaugh. And thank you all for joining us.